NACDL is the association of the nation's criminal defense bar.
Good afternoon, everyone, and welcome. We are at day 3, the final day of NACDL's 19th annual State Criminal Justice Network Conference. It has been a very full 2 days so far. I am very pleased and thank you to those who have been sticking with us from the first day and the second day. If this is your first time joining, allow me to introduce myself. My name is Monica Reed. I have the pleasure of serving as the Director of Advocacy for the National Association of Criminal Defense Lawyers. We are going to jump into this first panel discussion, which is going to be moderated by NACDL's own Kyle O'Dowd. He's the Associate Executive Director for Policy here at NACDL. So I will now turn it over to Kyle, who will introduce the panel.
Well, good afternoon, everyone. My name is Kyle O'Dowd, as Monica mentioned. I'm NACDL's Associate Executive Director for Policy. As a longtime sentencing reform advocate, some of you know I cut my teeth at FAM before coming to NACDL. I am particularly excited about moderating this panel with representatives from 3 highly valued NACDL allies. COVID-19 pandemic has made clear certain awful truths about our carceral system. I know many of you believe the adage from Dostoevsky, like me, that the degree of civilization in society can be judged by entering its prisons. Well, prisons are largely sealed off currently, but if you were able to gain access, what you would likely see is a callous disregard for life, including a failure to observe well-established safety protocols, inadequate testing, and grossly inadequate medical care. As of last week, there have been more than 95,000 COVID infections in our nation's prisons and at least 847 deaths. While certainly an undercount, these numbers tell us that we have not done enough to protect incarcerated persons, but they also tell us something else. They reveal the advanced age and medical vulnerability of so many behind prison gates, 2 characteristics that are shamefully related to race. And this brings us to our topic. It's almost cliche to mention that our prison population has ballooned since the 1980s, and many policies can be blamed for that. But chief among them are policies that mandate extreme sentences, including life without parole or life with illusory parole, and policies that sharply restrict the availability of back-end relief. Habitual offender statutes, mandatory minimums and enhancements for so-called violent offenses, and the twin policies of truth and sentencing and the abolition of parole have all played varying roles at both the state and federal level. But together, these policies are generally blamed for at least 50% of our prison growth in the last few decades. Recent years have witnessed an encouraging and somewhat bipartisan movement to reform our criminal justice system. But as advocates are aware, this movement has largely left behind persons serving extreme sentences, usually for offenses categorized as violent. And why is this important? Well, our panelists will unpack that further, but there are approximately 200,000 persons in state prisons serving life or virtual life sentences. If you're an advocate, you know full well the experience and frustration of working on a reform bill that excludes this population, either from inception or as a result of later negotiations. And of course, like so many of our criminal justice policies, this quote-unquote carceral exceptionalism, as it's been called, flies in the face of well-established research findings. Here to help us grapple with this challenging issue are 3 experts, each of whom brings something unique and valuable to the discussion. First, Amy Fettig recently joined the Sentencing Project as its executive director, filling the very big shoes of founding director Mark Mauer. Amy has spent her career fighting for the rights of incarcerated persons, most recently as deputy director for the ACLU's National Prison Project. There, she litigated challenges to prison conditions and led national campaigns to end solitary confinement and shackling of pregnant prisoners. Amy is a graduate of Georgetown Law School, where she has also taught courses in advocacy. Next, we'll hear from Marshan Allen, who is also starting a new job during the pandemic. Just this month, Marshan moved from Chicago to DC to take on the role of Research and Policy Fellow at Fair and Just Prosecution. Prior to this position, Marshan was Project Director at Restore Justice Foundation. He also serves as a board member for the Campaign for the Fair Sentencing of Youth, another one of our esteemed allies. And there is much more to Marshan's story, but I'll leave that to Marshan. After Marshan, we'll have the great pleasure to hear from Crystal Carpenter. Crystal is the Community Assessment and Engagement Manager for the Campaign for the Fair Sentencing of Youth. In this position, she works with directly impacted individuals, their families, and communities, and makes sure that stakeholders and policymakers understand the harsh realities faced by formerly incarcerated individuals and families. As I said, I'm going to start off with Amy. So Amy, I know this is a top priority for the Sentencing Project. If you could set the table for us by describing the issue and its importance to the broader criminal justice movement.
Thanks, Kyle. Yes, and thanks for having me on this panel and for doing this panel. Because frankly, for too long, the extreme sentencing in the United States has been overlooked. It's been overlooked in criminal justice circles. It's been overlooked as part of the effort that's necessary to end mass incarceration. So it's very important that we start taking a hard look at why exactly we have such extreme sentencing and what it has done to our criminal justice system. As you mentioned, we now have 200,000 people serving life sentences in this country. And just to give you a little context, that's more than the entire prison population in the United States in 1970. And that translates into 1 in every 7 people behind bars in prison in this country is serving a life sentence. We now have 5 times more people serving life sentences than we did in 1984. And just to look outside of our borders, because I think it is important for us to look at other countries and what the other human beings are doing all around the world. A study that was done on 114 countries, many of them very much like us and our size, found that the United States had more people serving life than the other 113 countries combined. We are more extreme in our sentencing than any other country in the world. So that begs the question, well, do we just commit more crimes? Are we a more violent people? And the answer, of course, is no. Human beings are pretty much the same across the globe. And in fact, when we look at crime rates in this country, while we've been putting more and more people away for life sentences, we've actually had 2 decades of decline in our crime rates and 2 decades of decline in our violent crime rates. In fact, our violent crime rate is now half of what it was in 1993. But despite that fact, the number of people serving life has doubled since 1993. So what that translates into is a mass incarceration system that cannot be fixed if we do not deal with our extreme punishment paradigm. It also translates into the fact that we've had a 400% increase in the number of elderly prisoners serving time in this country since 1993. And you might ask yourself, well, what's going on here? Why have we become so extreme? And I think the first thing it is to remember is we haven't always been so. Our extreme sentencing is a product of deliberate political and policy choices. We have changed our laws. We have increased LWOP. We have implemented habitual offender laws that have and mandatory minimums. All this we can talk about more has influenced the number of people serving life sentence. But whenever we look at a deep problem in our mass incarceration system, whenever we see something that we're doing that is extreme, that harms people, that's an outlier, we have to look at race. This is a racial justice issue like every other facet of our criminal justice system, because it's probably not a surprise to any of the advocates here. 2/3 of the people serving life sentences in this country are people of color, and nearly half of them are Black. That translates into 1 in every 5 Black people behind bars in prison in this country is serving a life sentence. So there's a racial justice issue here, absolutely. it turns out that in America, not only are you more likely to be imprisoned if you are a person of color, you are more likely to get a very extreme sentence. So we have to keep that absolutely in mind. We also have to keep in mind that this extreme sentencing and punishment that we inflict on people has nothing really to do with public safety. Recidivism for people who do get out who are serving life sentences or extreme sentences is lower than average. In fact, there are people who are out from extreme sentences are even less likely than the general prison population to recommit violent offenses. So it's not a public safety issue. We also know after decades of research that people age out. And that means that between the ages of the late teens and early 20s, that's where most people are going to commit their serious offenses. But once you turn 30, and all of us in the audience who are over 30, that declines rapidly. So that people in their 30s and 40s, 50s, 60s, they're not the same people. And they're very, very unlikely to commit serious offenses. This is hard science. Unfortunately, as we know, the facts and science have very, very rarely informed our criminal justice system. Instead, it has been about politics and culture of extremity, ill-informed by facts or actual needs. It has essentially translated into America thinking that public safety equals the number of people you put behind bars and how long you put them there, instead of investing in schools, education, housing, healthcare, as we all know all too well in this global pandemic. We've diverted precious resources, the time, the money, and the lives of millions in order to be extreme and be harsh, but not to be smart or just.
Well, Amy, I want to go further in exploring that issue. So the Sentencing Project has said that at the current pace of prison reduction, it will take 75 years to cut the prison population by half. So what solutions, you mentioned social program reform and services, what solutions, including those and others, should we be pursuing to accelerate this reform movement?
Absolutely. I think there's a two-pronged approach. There's the long-term goal, and our long-term goal needs to be capping sentences. At the Sentencing Project, we've proffered a policy that all sentences should be capped at 20, that we should never have a sentence that's longer than 20 years long. And that is a goal, that is a long-term goal, that almost anyone would get out after serving 20 years, if not sooner, and that there would be a second look at 10. But in order to solve this problem, which varies across states, even and is extreme in some places and less extreme in others, there's a patchwork of things that we can do. I look at second look laws as a potential way of really changing the dynamic. And that's especially for people who are already serving life in prison. So for example, Senator Booker and Representative Bass have the Second Look Act of 2019, which is a really good model. And this is for federal prisoners, but it's something that the states should look at too. And that is that everyone gets a review after 10 years. And there is a presumption of release unless a clear public safety threat is established by an expert panel of judges. And there is also a presumption of release for people over 50. So that's a great model to use. And we've seen actually states around the country in 2019, I think about 16 states introduced second look legislation to really take an unjust system and try to correct for it. So you've got second look legislation. But you've also got some states, and I point to Vermont, that is looking at a bill to get rid of LWOP. There is no place for life without parole in any just criminal justice system. It simply doesn't work. You know, I've spent 20 years working in corrections institutes, and I can tell you the vast majority of people who work in these institutions don't think life without parole is a good idea. There's no reason for it. People change. They should be given the opportunity to change. We also need massive parole reform. Our parole system is so broken in this country. It is politicized. It is not professional. We do not have experts making these decisions. And the people who come up for parole, like in the state of Tennessee, the first time you can come up for parole is after 51 years in prison. So the timing of looking at parole, the timing of second opportunities, you don't get parole the first time, you have to wait 10 more years. Why? That makes no sense. And we give people no roadmap, and we have very few metrics that make any professional sense in order to judge whether or not somebody can be released safely on parole. We also put the burden on the wrong direction. We need presumptive parole. And that would be a solution where we assume somebody's going to get a parole unless, again, an expert panel takes a look at that individual's characteristics, does an actual evaluation, and that would be mental health professionals, correctional professionals, not political appointees, finding that if someone needs more time in prison. Now, it's hard to imagine who actually would, but our parole system from top to bottom needs to be changed. And I would also point to the fact that clemency is very, very rarely used as it once was. So beefing up that clemency power, making it a real second chance for individuals who should be returned to the community, rather than what it is now, which is a rarely used political gift.
Well, thank you for that very comprehensive answer. And I guess I would add to the Booker bill, the model penal code has something very similar. And I think the Booker bill was based on that. And if I'm not mistaken, people can look it up. It's easy to find. But I believe it's parole consideration after 15 years.
Yeah, it is. It's 15 years.
And then,
whereas Booker's 10.
More regular review after that. Next, I want to get into the conundrum that we all face. So time and time again, our ambitious reform efforts result in compromises and incremental change. For me, the First Step Act represents that. And the issue of extreme sentences and relief for extreme sentences ends up on the cutting room floor. Sometimes, that's just a result of the political process, working with conservative allies and partners maybe, one cause. As we look to tackle this problem, what sort of strategies should we be pursuing and allies should we be trying to partner with in order to tackle this next problem?
Yeah, and there's no question, this isn't an easy fight and it's not an easy win. And so I would say at the outset, we have to be committed to real change, and we have to be committed that this is going to take a while, that there will be partial victories. We are not going to change this punishment paradigm overnight. But the important thing to remember is that we didn't always used to be this way. This is a fairly recent phenomenon. It is not set in stone. It was a product of real choices and real political decisions, and we can reverse it and we can make it better. So keep that in mind. But I do think also that one of the approaches that I've found critical in my work in prisoner rights reform is that when we're looking at who should be leading these efforts, who should be organizing, who we should be supporting, there's no question in my mind that these movements to end extreme sentencing need to be led by people who are directly impacted. These are the folks who are closest to the problem. That means they're often closest to the solution, as the saying goes, and it is absolutely true. But it's also that these are the folks that have the urgency to continue the fight. When you don't get everything you want and you have to go home with a partial victory, you need to get up the next day and be ready to move forward. And if you've got family members on the inside, if you remember your brothers and sisters on the inside, you're going to continue that fight. So these are the folks that we should be partnering with. These are the folks that should be leading this effort. There's no question in my mind. A small caveat that I will just also push, because I've had ample experience of it. In our movements, we must remember that formerly incarcerated women need to be a voice. They need to be leaders too, because too often in our incarceration system, the prison system, women's voices are not heard, and they are central to this effort. And in fact, more women, the number of women who are serving life sentences is actually growing faster than the number of men for many, many reasons. So I would say, absolutely, we need directly impacted people, not just to be stories. I mean, story banking is great, but that's not leadership. We need movements that are led by and informed by the experience of directly impacted communities. I also think that we need partnerships and collaboration writ large, though. This means that not just a few organizations need to take this on. This needs to be central to the effort to end mass incarceration, because extreme sentencing is the foundation of mass incarceration. We can't get rid of it if we don't don't get rid of our current punishment paradigm. So that means there needs to be collaboration from groups at the national, state, and local level. We need to be working together, and we need to be focused on not just the short-term wins, but the long-term struggle. You know, this, as I've said before, this is about changing the political culture and policies that made mass incarceration possible in this country. We need to make it impossible. And we can start now.
Thanks, Amy. That was a good segue to Marshan. So Marshan, your story really illustrates the importance of this problem and the human potential that gets just erased by these extreme sentences. Can you tell us a little bit about how you ended up where you are today?
Hi, Kyle, and I thank you and the National Association of Criminal Defense Lawyers for inviting me to speak today. As you know, this issue is very personal to me. It is dear to me because at the age of 15, I was convicted of 2 counts of felony murder and sentenced to 2 mandatory terms of life without the possibility of parole. You know, while I was in prison, I ended up using my time to, you know, try to better myself and earning certificates in business management and paralegal studies and computer technology and eventually associate's degree. But I always felt that the state of Illinois dealt too harshly with me and with some of my peers as well. And especially since I was not accused of being armed of harming anyone. I served and eventually served almost 25 years in prison before I was released in 2016. And that was only because the United States Supreme Court stepped in to declare juvenile life without parole sentences unconstitutional unless the state could show that the individual was permanently incorrigible. At the age of 15, I didn't understand why the state felt the need to charge me as an adult or with first-degree murder or to sentence me to die in prison. I didn't understand that. And for a lot of time, I was naive about the outcome. My attorney explained to me that if I was found guilty, I would be sentenced to mandatory life without parole. But I thought and naively that the judge would be able to do something about that. Like there was never any dispute about my role in this crime. That I had stolen the van, that I didn't have a weapon, that I didn't hurt or kill anyone, but I was still facing a sentence. And when I got to my sentencing hearing, the judge didn't want to give me life without parole. He stated that he would give me a lesser sentence, but he was mandated by the laws at the time that required him to sentence me to life without parole. And one of the problems with the sentence, life without parole and other extreme sentences, is that they forever label someone as irredeemable. And as a colleague of mine always says, like the judges and state's attorneys at the time of sentences, they do not have the ability to look into the future to see what a person will become. And so at the time of sentencing, you're sentencing someone for something they did at the age of 15 or 14, or in some cases even younger than that. And you're making a judgment against who they are and who they will ever be at that moment, and not having some mechanism in place where the person can be reviewed, as Amy was pointing out, a second look to see what this person has become. You know, people, especially children, change as they grow and mature, and people age out of crime. And I believe our legal system should recognize, they should nurture it and embrace that for everyone. It is my belief in second chance and the power of redemption that drives me to try to transform our criminal justice system. And I just think that we need to have a change here. As Amy pointed out, like we're the only country in the world that does this. And we're losing so much human potential by throwing away people's lives. I can't tell you the countless people that I've met in prison who became my brothers and my friends while I was there. After, you know, I served 25 years in prison, and I was in society almost 16 years when I was arrested. And I spent more time with these individuals than I did with my own family. And as I said, they became my family, they became my friends, they became my confidence, the people I leaned on when I needed help. And I think that a lot of them deserve a second chance, just as I got it. And again, I only have it now because of the Supreme Court decision, but some of them wasn't eligible for this type of relief because they may have been a year older. They may have been 19 or a day over the age of 18, I'm sorry, or 19, or they may have had a little bit more involvement in their case. But everyone deserves a second chance, and people change. And I think that our criminal justice system, or legal system, should recognize that.
Well, thank you. So the notion of centering impacted persons has come up multiple times during the conference, and Amy brought it up. And there's growing recognition among advocates that we need to do more to ensure this. Can you help us understand what that means, why it's important and advantageous to our causes, how we might incorporate this approach in our campaigns, particularly our campaigns against extreme sentences?
Absolutely. And I think Amy did a great job explaining why directly impacted people need to be involved in this process, and not even involved, just leading these efforts. But people who have been directly impacted by our legal system have unique experiences, perspectives that others do not have. They have direct knowledge of the operations of the criminal legal system that only someone with lived experience can have. They are aware of details and nuances that often goes unnoticed and recognized by outside observers. And they have personally encountered and gone through, every stage of the criminal legal system, and therefore have firsthand experience of its policies and procedures and the people who work within it. And I believe that their experiences, our experiences alone, make us experts about this system. So because of that, I think that directly impacted people in communities need to be involved as primary inputs of every advocacy effort, and not just as an afterthought. They should be at the forefront, as I said, leading these efforts. And quite frankly, they should be compensated for their time and expertise. But one of the ways that you can get involved, get formerly incarcerated people involved, is not just, of course, sharing their experiences is one way, but also getting their perspectives about the strategies that should be implemented and challenging these policies and procedures and things like that. Like I said, they should be involved at every single stage of the advocacy process and efforts. And I think that if they are not included, if they're just there to have their brains picked, if they're not leading these efforts, that the advocacy efforts and the movement is losing some vital, important tools or knowledge and expertise that could be used to help transform the system.
Thank you. Like I said, the issues come up multiple times during this conference, and I'm really glad that we're getting a chance to explore it more deeply today with this panel. Lastly, I want to ask you the same question I asked Amy, which is how do we shift the narrative, as this panel is called, around sentencing reform so that we can begin dismantling these longer sentences? In essence, how do we go about changing minds?
In 2018, I had the privilege of traveling to Germany and to Northern Ireland to view their system for youth, how their juvenile justice system. And one of the things that I learned in that process was how they treat people in the criminal justice system as people. They don't try to make them as others, and they still, in the signs in the juvenile facility, they don't have prisoners or inmates. They have it as young person. So they recognize the people's humanity and they respect their dignity first, and their policies is driven from that. And I think that is something that's missing from our criminal legal system and in society too, about people who are involved in the criminal justice system. But I think that, having said that, I think that the best way to do that, and then in my experience has been, is to personalize and humanize these issues. In my experience, I learned that a lot of the policymakers, they have big misconceptions about what the real issues are and the solutions, and as well as the people who they believe they're making these policies for. They see us as animals, they see us as super predators, they see us as people who don't deserve sympathy or mercy, and they don't see us as human beings, is the bottom line. And I think that that's the way to start to change the narrative, to let people see that we are human beings, that we made mistakes, but that doesn't mean that we should lose our place in society as humans and as citizens. But that's why I think, because of that, it's why it's important to involve directly impacted people and ultimately have them leading the efforts. And to give you an example, in 2018, when I started working in Restore Justice, they were pushing a youth for parole bill there. And during the summer, my colleagues and I, including one of the ladies, Judy Anderson, who's the mother of a formerly incarcerated juvenile, We drove almost 4,000 miles throughout the state of Illinois, talking to mostly Republican legislators downstate in Illinois about this bill and the importance of it. And prior to our meetings, it was unlikely that we knew this, that it was unlikely that any of these representatives have ever met with or had a personal conversation with someone who was formerly incarcerated, especially someone who's convicted of murder and served almost 25 years in prison, or as well as a mother who was currently of a person who was currently incarcerated. But these meetings allowed us to sit across from them and have a conversation with us and allow us to dispel a lot of the myth that they had about and to really personalize this issue and make them understand why it's important, that these laws are not making a difference and that they're actually harming people in communities. And ultimately, this effort ended up working, and we were able to pass this bill with bipartisan support in Illinois. It barely passed, but a lot of the people we went to talk to actually stood up on the floor, on the House floor, and actually spoke in favor of this bill. And we don't think that it would have happened if we had not made that effort to go and have this personal conversation and to have someone there who had lived experience and to share that with them.
Mm-hmm. Mm-hmm. So while we're on the topic of building bridges between different communities, between legislators who may not share our views, I want to show a short video that I think illustrates that point. And it literally involves a very famous bridge, and you'll see that.
In 2019, newly elected reform-minded prosecutors gathered in Montgomery, Alabama. Their goal was to gain a more nuanced understanding of the systemic racism in American history and to witness its direct correlation to mass incarceration. This gathering was initiated by FJP, Fair and Just Prosecution.
We're on a trip with some progressive prosecutors from around the United States to tour historic landmarks within the civil rights movement in Alabama.
Joining FJP were members of the Incarcerated Children's Advocacy Network, or ICAN for short. Their members went to prison as children and now advocate for youth sentencing reform. ICAN is an initiative of the Campaign for the Fair Sentencing of Youth, or the CFSY, which works to ban life without parole and other extreme sentences for children.
Coming down here to be able to have this moment with the district attorneys, to talk about, progressive ideas and to speak to one another with so much respect and admiration for each other's work and what we do. That alone going to, impact our work going forward.
Together, this group visited the National Memorial for Peace and Justice and the Legacy Museum. They hope to gain a deeper understanding of how America's racist past informs our current legal practices.
I think I've been reluctant to connect the mass incarceration of Black and brown people to slavery in the United States. It seemed like too straight a line for me. Having been to the Legacy Museum and the Peace and Justice Memorial, I absolutely have connected those dots now, and it does not seem like a stretch of the imagination. Every system that's created in this country has been created to reinforce the inferiority and the subjugation of Black people. Mass incarceration in the criminal justice system is no different.
Race plays a major role in the justice system. If you're brown or Black, chances are that you're going to receive a higher sentence. So people of color in the justice system tend to receive disproportionate sentences.
To shut down a wing of an adult prison where children are housed who are being prosecuted as adults. And there is some support in our legislature to do that. I would love for you to come speak about the benefits of just shutting that place down, because children should not be in an adult prison.
I took the life of my abuser, and I was sentenced to life without the possibility of parole plus 10 years. It took a lot for me to sit before you all today. They did not want to let me out of prison. They said I was the worst. It wasn't until Jody and the John Legends of the world and the Elizabeth Calvin's and Loyola Marymount colleges, when they actually came, they actually brought forth the truth I really love the space, the energy that you guys are exuding. I walked in, I feel it. I've never heard of prosecutors that care at the level that you guys care. I'm looking forward to going into those spaces and speaking and challenging their perspective.
For them to even sit here with prosecutors, knowing what they've been through, speaks a lot to their courage and really to their commitment to seeing the system dismantled. And it was great to have the same conversations, even for people who've been incarcerated in the United States. It is, I think they felt the same way that I did about making the connection between slavery and mass incarceration.
We have some photographs. I think maybe we'll just send a few of those around. You also might have seen some of the video in the Legacy Museum of the walk over the bridge. Those who've watched the movie Selma or seen the photographs, you know, pretty much looks just the same as it did at that moment in time.
The group then traveled across Alabama from Montgomery to Selma to walk over the historic Edmund Pettus Bridge.
It's really wonderful to tangibly stand and walk in places where leaders have worked so hard to break a system that's set up, have people fail. Overwhelmingly poor people and black and brown people. And so I'm here so that my story can be much more crisp and clear when I talk about the important work that we do as prosecutors, the power that we have, and how we can use it for good.
Being able to recognize my purpose after having been sentenced to life without possibility of parole, otherwise known as death by incarceration, as a child, and the only way to make sense of the trauma and the harm that that produced is having the opportunity to engage in trying to change the system. And one of the key players in doing so is obviously the prosecutors, district attorneys, who have the discretion to make a difference in a way that other entities cannot.
It was really very powerful to be standing shoulder to shoulder with people that had come in contact with the system, and we used words like that, but when you recognize that as children, 14, 15, 16 years old, they were sentenced to natural life without the possibility of parole. Many of them had served over 20 years themselves. Seeing the decency in them, the humanity in them, and the change that had occurred in that time was very powerful.
I hope long-term that can bring my office here and have my prosecutors really understand the connection between slavery and mass incarceration and what they do. And I think for me, I'm going to reprioritize things, especially the juvenile lifers, those folks who were sentenced to life as children.
To promote justice in youth sentencing, prosecutors can always take age and the factors of youth into account. Never seek life without parole for a child or someone who was originally sentenced as a child, and work to eradicate the practice of holding children in adult facilities.
So that is a great video. I guess co-produced by Fair and Just Prosecution and Campaign for the Fair Sentencing you've used. Crystal, I want to just turn to you, and is there anything you want to say about the video, how it came about, how you're using it, what the reception has been?
Overall, the reception has been great. The event happened months before the passing of John Lewis, and the most recently highlighted events across the nation that have put pretty much a spotlight on racial justice issues in our country. I think watching it after the unfolding of those events is something that I can't really put into words. It was a truly amazing experience. Over 24 prosecutors from across the nation joined our amazing network of incarcerated children, or amazing incarcerated children advocacy network, which is a network of individuals that were formerly incarcerated or sentenced to life or other extreme sentences as children. So it's continuing to impact the way that I approach the work, just having that experience alongside those individuals. And it continues to just be impactful to those that were on the ground, those that were actually part of that experience. It's something, I just can't even put it into words.
Yeah, it's a powerful video. And I think, it really illustrates, obviously, the humanity of the people who are being impacted by these policies, but also I think, as a policy wonk, I love the statistics and the data and the research, but I firmly believe we're not going to get ourselves out of this with data, research, and statistics that have existed, for, more than a decade or two. It's really going to take centering impacted persons. I honestly believe with this issue that is the linchpin. So I want to ask you, because you come at this from a slightly different angle, the juvenile angle. So the prevalence and racial disparity of extreme sentences is especially pronounced in that area. Can you describe the magnitude of the problem and what makes the juvenile context unique?
So the campaign has been, first, I know we talked about the video, but I want to thank you for that question. And then I want to first and foremost say that I am honored to be part of a panel alongside Amy and Marshan and yourself. So I truly want to thank NACDL for putting forth this conference and to thank all of those working behind the scenes to make this happen. Secondly, for those that do not know, the campaign has been laser focused on the juvenile lifer issue for over a decade. Amy really teed up the issue in her intro, just talking about the brain science and all those things that are there elevating this issue. I always draw back to a quote from Nelson Mandela wherein he said, "There can be no keener revelation of a society's soul than the way in which it treats its children." As Amy stated, and then a little bit Marshan touched on in his summary, the United States is the only country in the world that is known to sentence children to die in prison. One of the chief avenues for reform for us has been the U.S. Supreme Court. For more than a decade, the U.S. Supreme Court has consistently held that juveniles should be treated differently than adults. It's an assertion that's based largely on neuroscience, and as all parents or relatives of teenagers know or can attest to, a bit of common sense. In 2010, we had the Graham v. Florida case that specified that children cannot be sentenced to life without parole for non-homicide offenses, followed by the 2012 Miller v. Alabama decision wherein the court decided life without parole is unconstitutional for children in all but the rarest of cases. And then in 2016 in Montgomery v. Louisiana, the Supreme Court decided that its previous ruling in Miller v. Alabama should be applied retroactively. So those Supreme Court cases pretty much catalyzed change in the states as advocates worked to ensure they responded to Miller. When the Supreme Court decided Montgomery in 2016, over 2,800 individuals in the U.S. were serving life without parole for crimes committed as children. Since Montgomery, as you know, the campaign tracks the data, and since Montgomery, more than 600 individuals who formerly were incarcerated to life without parole as children have been released from prison, and that number continues to grow today. So there is a growing recognition about this issue and also sort of a awakening in the racial disparities that exist when it comes to delving out these extreme sentences. Over 70% of all youth ever sentenced to life without parole are people of color, right? So this is an issue. I know Amy touched on the overall numbers with mass incarceration, but when you delve into the sentences of children, it's not much different. Black youth, specific to this issue, are sentenced to life without parole as children at a per capita rate of that is 10 times that of white youth. So even with understanding of that perspective, there's acknowledgement that the majority of the country have rejected in law or in practice the draconian act of sentencing children to die in prisons. So in 2012, 45 states allowed JLWOP, or juvenile life without parole, and in the span of a decade, we've seen that we've seen the country flip. As I stated earlier, we have more than 600 people that are home. We have 23 states, plus the District of Columbia, that effectively ban juvenile life without parole sentences, and at least 5 other states with no one serving life without parole for a crime committed as a child. Amy talked about the recognition of aiming at, I think, the 20-year mark or less for a point of review for these lengthy sentences. The reality as it stands for states that have enacted legislation is that 25 years is the median alternative sentence before release and resentencing. So, and while 25 years is a significant step from life without parole, 25 years in our estimation, and as Amy talked about previously, is a crazy long time. And it highlights how out of sync our perspective is on appropriate accountability. And when you take into consideration the disparities, the racial disparities that exist in regard to this, it makes it a little bit more unbearable. As I highlight those statistics, I think of, or the numbers attached to that 25-year mark, I think about Ransom Watkins, Andrew Stewart, Alfred Chestnut. Those are 3 individuals who just in November 2019 were exonerated in the state of Maryland after serving 36 years for a crime they were accused of at the age of 16. I also thinking about your intro, Kyle, when you talked about COVID, the first thing I thought about was William Garrison. He was a Michigan juvenile lifer who died of coronavirus in prison in April. William was due to come home from prison in early May, but unfortunately passed away on April the 13th. He has served nearly 44 years in prison. There are many more Williams and Ransoms and Alfreds in prison cells today awaiting an opportunity for release. So we have come a long way, but we are not quite where we want to be. And conversations like this one is a crucial step to sentencing reform in the States.
So, Crystal, obviously the Eighth Amendment has been particularly fruitful in securing relief for juveniles with extreme sentences, unlike their adult counterparts. And you've been at the forefront of those issues. What's next? What are you? What types of measures are you seeking in state houses currently?
So, with the recognition of the Supreme Court Supreme Court outcomes catalyzing the movements on the states, the campaign pretty much pivoted to leading efforts in statewide campaigns to ensure states were brought into conformity with the Miller decisions. We have approached it with pretty much a multi-pronged approach. So creating coalitions within each state is key to this effort. And it is important to Amy and Marshawn's point that those coalitions meaningfully include, and to the extent possible, are led by those that are directly impacted. Those directly impacted should be viewed as subject matter experts on this issue and should have a voice in the matter that is reflective of and or takes into account their lived experiences. We've seen that such coalitions have great outcomes in Nevada, and where the local folks there really did their thing. The legal community stepped up, and there was accountability from the state to make sure that there were releases. Strong local coalitions are critical to this effort. More recently in Virginia, the Family Network came together to turn the tide in Virginia. Despite what the prospect looked like, they participated in monthly meetings to discuss strategy and to gain an understanding of what other states were doing as they continue to mobilize on the ground through educating existing and new leaders in the state on the issue. That effort was truly phenomenal to witness over the past few years. And then implementation is a key part of the process and something that a lot of people often leave out. When laws are passed, it is important to have the coalitions and the teams in place to ensure things are working the way you envision. When our bill passed in Washington, D.C., which is a bill that ultimately allowed individuals that were sentenced an opportunity for judicial review after 15 years, we had to do the work to ensure that those affected were positioned for the best outcomes. So that meant active recruitment of attorneys to ensure that as many impacted people as possible were represented by effective legal counsel. We had to provide attorney support. We hosted several training sessions and gave ongoing support to ensure that attorneys are knowledgeable or were knowledgeable on both the law and the realities of the prison system, mitigation work, the reentry landscape. We also went to hearings, which was unique to a lot of coalitions work. And that the purpose of that was to identify trends, obstacles, and opportunities in an effort to inform future case strategies. So, you know, as you have recognized earlier, or Amy recognized earlier, and even Marshan, the resentencings and parole decisions are to some degree highly discretionary. And to be honest, they may be tainted by judicial and racial biases. With little guidance from the Supreme Court in Miller and Montgomery on the specifics of resentencing process, states have varied significantly in the procedural protections that have been afforded. And I think the best example that I can give to highlight that is Mr. Henry Montgomery from Montgomery v. Louisiana case. In that case, the Supreme Court deemed him a model prisoner, right? And yet to this day, he has been denied parole by the Louisiana Parole Board. So it's a lot of work to be done. And I think one of the most crucial parts of this was making sure that, I mean, that's often this as well, is making sure that those that are released under the bill are supported in their return to the community. So establishing relationships with local service, reentry providers, or government agencies. In Washington, D.C., one of my colleagues, Eddie Ellis, created a support group that was recently featured in the Washington Post, right? It is one of the most well-attended meetings in D.C. for a specific cohort of this kind, namely those that have been in prison since childhood. And it's more of a peer-to-peer model. They focus on self-care, they get supports that they need, and it's a level of accountability attached to it within their own cohort. So it is amazing. And then I think the final piece to that puzzle on the statewide legislative advocacy efforts would be ensuring that people think about continuously reviewing policies and legislation that may thwart our efforts. And I'm thinking about what Amy spoke to earlier to some degree. So you pass legislation, you work on the implementation, but I guarantee you that there will be one legislator that may be in a reactionary effort or manner tries to enact a law or policy that might lead to enhancements or mandatory minimums, or and we've seen that in some places. So it is important that coalitions stay on the ground, informed, and continuously keeping an eye on those things that may impact the population of people that we're advocating for.
Thanks so much, Crystal. And as testament to this panel's excellence, we've received a number of wonderful questions, and I do want to save a little time to get to those. But Crystal, if you indulge me just one more question for those who aren't big Supreme Court watchers, and I hope I'm not getting into uncomfortable territory and asking you about this, but I'm wondering what your thoughts are about the Jones versus Mississippi case that the Supreme Court has agreed to hear. You know, what's at stake there? What sort of legislative follow-up we might see as a result of that case? Just to put people on notice that there could potentially be some work to do as follow-up.
So when it comes to the Jones v. Mississippi case, I think we believe that Miller and Montgomery clearly said that kids can be rehabilitated. Kids that are rehabilitated cannot be given life without parole, right? And there are now cases where that is not being faithfully implemented. So there needs to be some enforcement mechanism to ensure that moving forward, the cases are faithfully implemented to avoid these unconstitutional sentences. That said, the Jones case is a very narrow question of the law, right? Asking some of the specifics of what Miller demands. So no matter what the outcome is, we have seen that state legislative reform has outstripped what the Supreme Court mandates. We've seen that in DC, what I just referenced, West Virginia, Even Virginia, most recently, they not only banned life without parole, but they banned de facto sentences too, and providing that children were given sentences greater than 15 or 20 years, depending on the state, were afforded a meaningful opportunity for release. So plainly put, I would say, there is no possible outcome in Jones that would preclude states from enacting legislation that would do the right thing when it comes to sentencing reform.
Right. Thank you. So I want to get to a few questions because they're all very good. And the first one comes from Kimber Watts. She states that she's from a state that recently abolished the death penalty. And during the years working towards abolition, several of their legislative supporters and persuasive advocates made promises that they would work to retain life without parole. So bargaining that this wasn't just the nose under the camel's tent, that they would keep life without parole, presumably as a political bargaining chip. Any advice on strategies for coping with those kinds of political trade-offs when advocating for changes in the future? I am interested in ideas for how to reframe the issues and/or to make more palatable for those people making a shift in their position. I want to turn to Amy, I think, maybe because there's a death penalty issue there, and we're all abolitionists in that regard. I think probably most of the people tuning in today are, and realizing the just unmanageable horror of taking a life, of the state taking a life. It's something a lot of us feel very strongly about, and think it's the worst thing our justice system does. And so it may lead to some of these trade-offs. But how do you suggest dealing with something like that, Amy? I'm sure you've encountered it.
Yeah, and it's complicated. And I think it's important for us to take a look at what's happened, because the paradox that Kim was talking about has happened across the country, where in order to abolish the death penalty, stronger, more broad LWOP laws have been put in place. And the result of this, the result of pushing LWOP more broadly, has often meant that people who would never be capitally sentenced, ever, now have LWOP. So it's actually spread LWOP more through our system, normalized LWOP. So now we have more people serving LWOP than we ever have in the history of this country. So I would strongly suggest that we stop agreeing to this trade-off. We need to make the case why LWOP is not appropriate. Life with the possibility of parole exists. It's still a life sentence. I mean, I don't agree with that, but I say draw the line at LWOP. You're sacrificing way too many people for very, very little good. It's a process of more education. And as a former litigator, I understand that the capital attorneys, oftentimes they have to make this trade-off. But let's start moving away from that, because not only does death ratchet up all of the sentences in this country, but LWOP does too. We have to be pushing against any form of extreme sentencing. And again, this is a process of education for lawmakers. It doesn't make our job easier, but it makes it better. Carve-outs, while sometimes strategic, always mean we have to go back and do more work. So keep that in mind as well.
I think this one might be for Crystal, but it might be for Marshan. So either of you just jump in, maybe Amy, I'm not sure. This is from an anonymous attendee, and they want to know if we have any thoughts on blended sentencing for youth charged as adults. So anyone with a background on that type of mechanism?
I think I understand what he's talking about, and if I state it correctly, it is when a juvenile is charged as an adult, but he is given a juvenile sentence, and if he completes that sentence satisfactorily, he's fine. But if he gets into trouble while he's like on juvenile probation or even carrying out a juvenile sentence, he can be given an adult sentence. So it's actually the blended sentence is given a juvenile sentence and an adult sentence. And I don't think that any child, and I'm gonna make this really, really simple, that I don't think that any child should be given an adult sentence. Plain and simple, that juveniles should be treated as juveniles, and that's it.
Thank you.
I agree.
So a couple more questions. One is just very easy from our good friend Angelin Fraser-Giles, who's going to be moderating the next panel, I think. And it's to Amy, and just asking if you can list the 16 states that are contemplating second look legislation. Is that something that's available on the Sentencing Project website, or something that we can provide to our attendees?
Yes, actually, I would go to, we have a what's called a microsite, I'm told, and it's endlifeimprisonment.org, where we list various actions, both federal and state. I would look at, as I mentioned, I think the best language is really the Booker bill at the federal level. I think that's the best model that we have. So I would start there. And various states have taken different approaches. I'd look at Massachusetts. I'd look at Missouri for some interesting stuff that's going on. I would also, not in the second look context, but in the context of abolishing LWOP, which I think is incredibly important. Vermont is really on the verge of doing this. Take a look at that bill. They have the support of their DEA there, their AG, I should say. So that's a very interesting bill too. But definitely go to both the Sentencing Project website and the endlifeimprisonment.org. Concentrates all the resources and current. We collect basically every article of any importance and the news there. So it's a great catch-all resource.
Thank you very much. And then our final question from Catherine Cooper. How do we combat the response to sentencing reform that the reduction in crime since the 70s is the result of extreme sentencing practices in the 80s and 90s? I think I know the answer to this from an article I read by your predecessor, Amy, but maybe you want to field it?
This area actually has been researched a great deal. Looking at, what is the value of, it's called incapacitation. The theory being if you just lock everybody up, nobody will commit crimes. And it turns out that you can actually measure how much imprisonment impacts crime levels. And it's not that much. Certainly not to the level that we have done. We have far, far exceeded any public safety value that we would have ever gotten out of imprisonment. I think the better question we need to ask, and perhaps the tougher question that's going to require us to start rethinking, again, that punishment paradigm, is how do we deal with violence in this society in a more constructive way? We've seen that narrative shift, the pivot away from, for example, treating drug addiction as if it was a moral failing. And we're now framing it more as a public health issue. We need to do the same thing for violence. We know that trauma and abuse fuels violence. We can actually trace the causes of violence in our communities. Our problem has been we've done very, very little to prevent it, and we've done very, very little to heal people from it. And that is because we're putting all of our resources into prisons and jails. So let's rethink how we deal as a nation and as a community with violence, with serious offenses. And let's start investing in our communities to prevent violence, to deal with trauma, and to use a public health frame so that we end up having communities that are not decimated by mass incarceration, but healed by our understanding of what it means to be a just human being.
And if I were going to add on to that, which I'm hesitant to do because it's so eloquent, I would point you all to an article by Mark Maurer that's included in the materials, where he just summarizes the research. And I guess it's the high water mark of the percentage of that decline that you can attribute to extreme sentencing. Maybe there's one isolated study that puts it at 25%, but most of them put it at much less, so somewhere between 5 and 25%. But flip that on its head. What does that mean? That means that at the least, I'd say 75% is not attributable to those increases. So we need to stop looking at just the benefit side of this. We need to start looking at the cost benefit, as Amy alluded to, and what other policies would more effectively achieve a safer and more just society. So I want to thank all of our panelists. I want to thank the people who attended today. This is an issue that's near and dear to my heart. Certainly the next big thing. We've been picking the low-hanging fruit for some time now, and at some point we are going to need to get serious about this issue, and I hope you took away some strategies that will enable you to do that. I like to quote Elie Wiesel, the Nobel Prize winner. Our lives no longer belong to us alone. They belong to all of those who need us desperately. And I cannot think of a community that needs us more desperately than those serving these extreme sentences. So I just commend all of you. It's such an honor to be on this panel with you. I commend all of you for your work. And then I have some brief concluding remarks, a plug that if you've been tuning in, you've probably heard before, but I'm going to tell you anyways because it's important and it enables us to do what we do, to put on conferences like this and all the other work that is so essential to the role that particularly the defense bar plays in these efforts. So if you enjoyed today's session and you would like to support NACDL and its mission, there are many ways to do so. If you're a criminal defense lawyer, you can become a member and strengthen our voice and receive access to numerous benefits. In addition, you can make a charitable contribution to the NACDL Foundation for Criminal Justice by visiting nacdl.org/foundation.